In this video, we will be talking about Labor Relation Act. This act was implemented or was developed to ensure that there is a sound relation between the employer and the employee. When we say sound, it creates a framework. In other words, when the employer will know what to do, and then the employee will also know what to do in terms of disputes, in terms of misunderstanding between these two parties. So that is what we will be talking about in this video. Now, the purpose of Labor Relation Act. We've got 6 purposes of Labor Relation Act. Our first purpose, it provides and enables the framework and structure for labor relations between the employer and the employee. When we say framework, guys, it gives a guideline on in terms of how the employer should conduct itself, how the employee should conduct itself. That will be the first.
How to behave and how not to behave.
The second one, it promotes a collective bargaining at a workplace. When we talk about collective bargaining, we're talking about they bargain to negotiate. It gives a platform for both parties, the employer, to negotiate their terms, their conditions, their situations. And the third point, it promotes the simple procedure for the registration of trade union and the employer organization. Trade union, it's an organization that represents workers in a workplace. And then we've got employers organization. Employers organization is a union that represents the employers in the workplace. For example, we've spoke about trade union. It's an organization that represents employees. We are familiar with SADTU. You learners, you are also familiar with SADTU. It's a union that represents teachers. For example, if the employer doesn't want to increase the salaries of the workers, or of teachers, so therefore, trade union as well as employers organization, they sit down collectively and negotiate on those increases until both parties they are happy with that situation. The fourth point, it promotes fair labor practice between the employer and the employee. Now, when we say fair, something that is regulated according to law, what the law prescribed for the employer, what the law prescribed for the employees. So it promotes that. The fifth point, it establishes the Commission for Conciliation, Mediation and Arbitration. In short, we usually say CCMA. And it gives a platform for labor court. It gives a platform for appeal court. Now, this system, it is used when both parties, they don't come to a conclusion. So therefore, they refer their matters to those people. If for example, if your mother is dismissed unfairly in a workplace.
Dismissed.
Therefore, it can take his consent to CCMA. Therefore, they will start and try to resolve that issue. Our last point, the sixth one, it advances social justice, labor peace, economic development, which ensures that the workplace maintain the basic rights of the employees. So through these purposes, we've learned that the business can maintain the justice for employees or laborers. We are going to talk about the impacts of Labor Relation Act. Remember, ladies, when we talk about impact, we are talking about the advantages as well as the disadvantage. But now we are going to start with the positive impact, the advantages of Labor Relation Act. Our first point, it ensures the participation of all parties in collective bargaining process, which reduces the conflict in the workplace. So now all parties must be involved. If there is a conflict, both parties, the employer should be there, the employee should be there, and sit down and try to resolve the issue. So this act ensures that all parties are there to resolve their conflict so that there will be harmony in the workplace. The second point, it protects the rights of the businesses and the employer organization in a labor-related issues. Now, it means if there is an issue, there is a dispute, a misunderstanding, it ensures that there is both parties, the employer's organization will be there and the trade union will be there. The third point, it promotes quick and less expensive labor dispute resolution. In other words, you are not going to spend too much money in order to resolve those disputes, but it's going to be less because already there is a platform that is created by this act to resolve the issues. The fourth point, it protects the employers who lawfully wants to conduct a lockout when negotiations between the parties fail. Lockout is a system that is used by the employers to lock the premises, lock the employees outside the working premises, because when employees are heated, they are angry, they come in and they vandalize the working premises. So now the law grants these employers the right to lock their premises so that their premises they be safe. The fifth one, it prevents unfair discrimination in the workplace because equal opportunities are promoted for all employees.
Less discriminating.
So it ensures that there won't be discrimination in the workplace. You're not going to favor the other employee against the other one. So we are going to prevent the unfair discrimination. The last point, it provides sound dispute resolution through consensus between the organized labor, business, and the state. Now, when we say consensus, there will be an agreement between these parties. The other one will agree. Therefore, there will be a sound, definitely, there will be a sound relation through what? Through consensus. That is developed by what? Labor Relation Act. So that is all about our positive impact. Therefore, we will be discussing the negative impacts.
-1. It's a -1.
Now, the negative impact, the other way, the disadvantage of Labor Relation Act, the first point says the Labor Relation Act may reduce the global competitiveness of the business due to lower work productivity. What does that mean? It means through this Labor Relation Act, the laborers they are granted the right to strike.
We're going on strike.
So when they are busy protesting, these workers, the productivity definitely it will be low. So you cannot compete with the globally countries because the production it is already low. Then the second point, the business may lose their competitive advantage because it is important because of this law.
The business may lose their competitive advantage because important information, which could be leaked to competitors, is often disclosed to trade union members during collective bargaining.
The other point, it decreases the profitability of the business because of decline in productivity. When workers are there toiling, the productivity definitely it will decrease. At the same time, the profit of the business will decrease. Then the fourth point, productivity may decrease significantly if employees engage in trade union related activities
During working hours?
Now, when we talk about trade union related activities, maybe the workers, they're supposed to go and attend a mass meeting somewhere where they're going to discuss on how to resolve those issues that they have. Therefore, by that time, the productivity, it will decrease because they take a working time. Point number 5, the implementation of Labor Relation Act may be very costly and time consuming. If the business want to implement labor relations, it's time consuming and it's very expensive for the business. The last point number 6, the employment of legal specialists and labor consultant increase the cost of the business. So if there are issues, the employer, it is forced to employ specialist legal people so that they try to resolve the issue that they have. So it will be costly for the business to do that. So that is the end of our part 1 of Labor Relation Act. Therefore, the next video we'll be talking about compliance and non-compliance and the rights of the employer as well as the rights of the employees. Thank you for watching our video. Please subscribe.